Nobody wants to end up in family court, but if you do, you want an honest, experienced family law attorney by your side to help minimize the stress, mental anguish, and legal costs that divorce and custody matters bring. Welcome to In Your Best Interest. Texas divorce attorney and entrepreneur Justin Sisemore of the Sisemore Law Firm, entrepreneur Andrea Jones, freelance writer Mary Maloney, and guests share insight on what to expect and how to handle family law matters, the changing landscape of family law, and living the entrepreneur's life. Now, on to the show.
While the best interest of the child is top priority in child custody cases, different states approach child custody differently. In this episode of In Your Best Interest, we'll discuss how the Texas family courts approach child custody, what it takes to get sole custody, what parents need to do to reassert parental rights, and more.
Thanks for joining us for this episode of In Your Best Interest. I'm Mary Maloney, and today attorney Justin Sisemore, entrepreneur Andrea Jones, and I will be discussing the ins and outs of child custody in Texas. Justin, let's start off with the different types of custody arrangements available here in Texas. Can you explain the basic differences between sole custody and joint custody, for example? And then how is Texas different in the way they approach custody than other states?
So sole custody and joint custody are really broken down into several different areas. One is the rights and duties, two is the possession and access, and then you have the financial aspects. So when you're talking about sole managing conservatorship, you're really dealing with exclusive rights that don't require you to get the consent of the other party. The big three, as we call them, are the right to establish the residence, the right to make medical and psychological and psychiatric decisions, which are really lumped into one there, and then the right to educational decisions. So when you have joint conservatorship, you'll generally see provisions or language that is subject to the agreement of the other conservator in the event that you want to change schools or change a scholastic program that your child or children are in, or medical decisions. You've got a parent that has the right to make psychiatric or psychological decisions. Many times that involves whether your child is medicated for any kind of learning disability. And in joint conservatorship, you would generally have subject to agreement provisions on those psychological and psych. You also see scenarios where one party has the trump card, if you will, after consultation, and that category can still remain in the joint conservatorship realm. But when you go to sole, you generally have situations where there's been family violence or a total lack of cooperation from the other party. So when I hear people say, I want custody, I want, the children fully to me or full custody, that's, they're talking about the rights and duties and then the possession and access. And so with respect to sole, you don't have to get the consent of the other party, and you generally don't even have to consult with them because there's been family violence, or you've tried to consult with them and they never cooperate in the consensual decision-making for a child. So the court can actually change the order and allow for a sole managing conservator to exclusively have those rights. So that's the conservatorship portion in a nutshell. And there's several other enumerated rights in the order itself. Many of them don't come into play. The right to service and earnings of a child, we've talked before, unless your child is Macaulay Culkin or, they're going through some scenarios. And even with NIL or name, image, and likeness, many of those provisions don't kick in until the age of 18, or they're not supposed to. So we haven't really seen that pop up as much. And many of those rights don't really come into play. There is the right to religious and moral training of the child or children. You don't really see that come into play a lot either, because courts don't generally like to interfere with your right to your First Amendment rights for the child. So those big three are really the ones we fight for in conservatorship. And then possession and access, the family code's actually changed as of recent in the last couple of years, where you used to have a standard possession schedule, which is your first, third, and fifth weekends, Friday to Monday, and then the Thursday from 6 to 8 on each week during the regular school year. That's actually changed to the best interest of the child being presumed, that the expanded standard is in the best interest, which is your Thursday to Monday on the first, third, and fifth, and your Thursday overnights. And so that breaks down to about 46% of the time, 44% of the time, depending on the calendar year. And then we hear a lot of calls on the 50-50 and what that looks like. So obviously 7 days in a week. There's a 2-2-3 schedule. One party has Monday, Tuesday, the other party has Wednesday, Thursday, alternate the weekends, or you have a week on, week off scenario. So there's different ways to structure that. And it really depends on whether you're filing for a modification or an original petition on what you can do and whether those rights impact the parent with the right to establish the residence on the visitation and access. And then the financial aspects of it, or the third prong of the custody consideration, is the child support. So obviously the possession and access schedule can impact the child support depending on the amount of time one party has. And even with 46% of the time, I hear all the time, well, I've got the child, 46% of the time, and then wife or ex-wife or mother or dad is asking me to come pick up the child on Thursdays, and then I have them during the week. And so you see scenarios where parties feel that the statutory predicate that requires the 20% for one, 25% for two, 30% for three kids is unfair or unjust. And we've gotten into that before, but the code really enumerates, if you have an expanded standard schedule, even if a party's giving you more time with a child, that child support is statutory. And, we get into caps where if you make, $20,000 a month, the court still treats it as if you make $9,300 a month. So what that means is if you're multiplying the 20% for one or the 25% for two, that $9,300 is where you do the multiplier. So that can be unfair if you represent some athletes who have, or actually if you're on the side of the mother or father of the non-breadwinner, where those caps exist. And also if you're right at the threshold, but you're getting about 50% of the time, it can feel very unfair because you're getting 20, 25, 30% of your income dinged, and you're right there at that threshold cap. So those are the three aspects of custody in a nutshell.
Okay. Going back to sole custody too, a lot of people come into your office saying, I want sole custody, but it's not really that easy to get. Can you explain what people need to show or prove in order to get sole custody?
In the family code, we have presumptions, and those presumptions are designated and dictated by statute. Okay. So one of the presumptions is that joint managing conservatorship is in the best interest of the child or children. So because of that presumption, what you're dealing with is the court, in order to go away from the joint managing conservatorship, or JMC as we call it, to get to sole, you have to show by clear and convincing evidence that joint managing conservatorship is not in the best interest of the child or children. And again, that goes back to family violence or situations where one party is just non-participatory in the child rearing, or they just completely create roadblocks in scenarios where a parent is trying to make decisions in the best interest for a child. So when I hear people say they want sole just out of the gate, I tell them, look, we can do a lot of things that create this sole environment where you have the trump card, you have the parent with the right to make decisions, but you don't have to call it sole. So it's more palatable and easier for the court to make decisions, to sign off on the order, and you don't have the burden of proof with the evidence that's necessary to get to that threshold, which saves clients money in the long run.
All right. Well, I'd love to call Andrea into this conversation because she's gone through some custody battles with you as her attorney. And Andrea, you had to navigate a challenging joint custody situation where you shared custody with your ex, but you managed to make it work. So can you share any tips for parents in a similar situation?
I think the most important thing, and Justin shared all the differences and where you can make decisions as a parent. The most important thing is that you have most of the rights. I think that's the most important thing for me. I had the educational right. I had the right to determine where we could live. And then medical decisions, of course, we did. It's always the most important thing is always look at what the kids, what's in the best interest of the kids. I think that's the most important thing. And we forget that sometimes in thinking what we would like to have or what would work for us. But the most important thing is what's in the best interest for the kids. And you have to take yourself out of the equation. What helped me a lot is to look at my own parents. How would I, as a kid, have felt if I would only be able to see my dad, or only be able to see my mom, or if I only be able to spend weekends with one of them? You don't want that. You would want both of them. Kids love both their parents. And even if you disagree with what the other parent is doing, for example, we eat healthy at our house, the other house eats unhealthy. is it really going to kill the kids if they have McDonald's a whole weekend with the other parent? It's not going to kill them. So you have to take yourself out of it and then just really see, or really think about the kids. There are going to be differences, and the differences, you're not going to fix them. You didn't fix them in your marriage, so you're for sure not going to fix them now when you're separated. So I think that's the biggest part. And I made lots of mistakes and tried to control the situation. You can't control the situation. So if you have most of the decisions you can make yourself, that's important. And then again, look at the kids. What do the kids need? And kids are very smart. They figure it out over time. So there were lots of issues that we had, but at some point, take a step back. Kids are smart. They're going to see who's a good parent. They learn from bad situations too. And unless the kid is in any kind of danger, they're going to be okay. Kids are very resilient. And again, if there's danger, then you need to step in. But otherwise, just let it go. The kid's going to be just fine.
Yeah, Mary, I do want to, it's really important that when we say soul managing conservatorship or I want soul, that doesn't mean 100% of the time or 100% of the rights. Those are different tranches inside of soul, right? So when someone says I want soul conservatorship, what's really important for them to get out of that from their lawyer when they're doing a consultation is what is soul managing conservatorship, because it does not mean 100% of time. And it does not necessarily mean 100% of rights. It can be sole rights individually inside of that rights tranche, and it can be different possession and access. So when they say sole versus joint, that doesn't necessarily mean that it's going to change the possession schedule, and it doesn't mean that they're going to get sole on all rights. Andrea pointed out, if you don't have issues with medical or psychiatric decisions, specifically medical, let's just take that one, break that one down. Those are medical rights that involve invasive procedures that are non-emergency. Okay. So that's really important to distinguish. That doesn't happen very often. Hopefully it never happens to your child, but to spend hundreds of thousands of dollars or tens of thousands of dollars fighting over a medical right that doesn't involve an emergency, but an invasive medical procedure sometimes can really be just, I'm going to use the word dumb, because it doesn't happen a whole lot. And if you don't have a child with a lot of specific medical, surgical, invasive procedure needs, then you spin your wheels and a lot of resources that you may not need to.
And I can support that. We have 4 kids, and with all 4 kids, there was never a situation. And they're now, the youngest ones are 17. There was never a situation where we had to cross that bridge. Never. And if anything happens, you take them to a doctor. You inform the other person what's going on. They can come to the doctor, or can come to, even if they have a hole in the head, go to the hospital. You can let the other parent know, and then you take it from there. So it's not really not that important. But residence is important, for example, where you can live, and educational decisions is important. The medical, we never had issues with that.
So kind of as a follow-up to you, Justin, too, then Andrea kind of shared some tips on how, she made it work. And obviously she made some mistakes along the way. How do you counsel clients on taking certain steps or to keep themselves out of trouble or keep themselves from having a lot of challenges with the other parent? What are some good tips you could provide to your clients, or that you do?
I think the biggest thing, Mary, is to remember that if you stop projecting and just start stating facts in your communications, you're crazy. This child, just goes over there and they can't stand being over there. They don't want to be with you. You have that kind of communication, you're going to shut the other side down. So what I always encourage clients to do is just kind of take the wind out of the sails, as I call it. Ask the other parent, hey, we've got these issues coming up with this school. I wanted to get your take on it. Even if you don't care what the response is, simply asking that question and letting them know that they can participate in the communication is probably the biggest key to allowing some form of open communication. And I tell clients this all the time. I don't care if you're completely faking this. If you want to have a bullet for the gun, I always use the bullet for the gun analogy. If you want to have a bullet for the gun, ask them their opinion. Either they don't respond, that's an exhibit number 1, or they do respond, well, pound sand, you're a terrible mother. How could you do this? You're a bad father. You're not there. You don't know. When you're asking open-ended questions and you're presenting that fact pattern to a court in the form of evidence, hey, judge, look, on March 13th, I sent an email request asking the other party about their opinion of the doctor and who they would recommend. And they said, you're a terrible mother. That's their response. How do you think that looks to a judge? Well, now all of a sudden we're getting into the conversation of whether that parent even needs that right anymore because they're putting up that roadblock we spoke of. And now you have actual evidence of it. So, I get parties all the time. They come in and they think they have this evidence that is going to be the deal breaker or deal maker in a custody case. And they say some very terrible things. And then they're like, Justin, look at this response. And I'm like, well, did you see the first part of that text message or that email communication? So I really try to get people to do the do right rule. I tell people all the time, the reason I do this job is not to go divide up toasters or decide on an extra Wednesday or Thursday. It is to make sure that kids are not involved in an environment where they have two parents that are going at each other's throats. And when you get them out of the middle of that and you have one parent that's doing the right thing, even if the other parent is not, but we're doing our part and our client's doing the right thing, at least we can do one of two things. We can either shut that other parent out of that decision-making altogether, or we can show a court, hey, listen, this other party is the bad actor. They're the one that needs to go to co-parenting counseling. They're the party that needs these injunctions in place. And so those are the bullets for the gun, and not that, I want people thinking, well, how do I get the bullet for the gun so I can go shoot this person? But sometimes it's necessary. And sometimes you have to have that information available for clear and convincing evidence to show a judge that those decisions need to be had by one party.
Kind of taking a little bit of a turn here. So there are some situations that you've dealt with as an attorney where parents want to reassert their parental rights. They say they've been out of the picture for a while, maybe they've spent time in jail or they've had substance abuse issues. What steps must they take to regain custody or at least get more access to their kids?
So I'm going to go by the way of example here. One of my favorite clients of all times, and I have a lot of people that I really, really care about and think about, but one of my favorite clients of all times came into my office completely intoxicated multiple times. And you could tell he was a good guy, but he was really struggling with addiction. And, the tape recordings of his son and him in conversation really would make most people cringe. And over the years, I finally said, hey, listen, you can continue to pay me a bunch of money, but at the end of the day, if you don't do what I say and get yourself in check, what's going to happen is you're just going to throw money at the wall. Nothing's going to come to fruition, and your child's going to suffer from having you out of his life. And candidly, I don't want you in your child's life if this is how you're going to behave. And that may frustrate you because I'm your attorney, but I don't just walk around going, hey, let's put addicts and drug users and abusers in a position of control because I'm good at litigation. I don't do that. And so in that situation, that client had to be basically reinstituted into the general terms of visitation and access. And it started out with supervised, and, it started out with Saturdays and having some people watch him. And then it turned into more and more and more visitation because the client actually made this massive life change. And the other party is always going to doubt whether that person is capable of that life change. But what I saw was a true change in not only the mindset and heart of my client, but how he actually interacted with the child, the quality of interaction. And, what actually ended up happening in that case was the mother just never let the past go. And the court saw that over time, and they said, look, I don't know what else you can do. He's got all these stars from, sobriety, and he's got these people, and he's not trying to take this child away from you, man. But you're getting to the point where you're crossing that alienation bridge where you are telling the child that the dad is a drunk and he's never going to repair and he's never going to be okay. And all the while you're telling that child that half of him or her is a bad person, is a drunk, can never make changes. And so the court actually did a total custody flip in that case. And it took a long time, and it took a lot of resources and a lot of patience and a lot of trust. But the reinstitution, we don't like to just jump right in. If you've been a parent that has been uninvolved because of your own doing or because the other party has shut you out, the courts aren't generally just going to throw you back into the mix of that visitation and access. And that can feel like you're watching paint dry on the wall, and it can feel like too much time is going by. but the reinstitution is really important for the child's sake, okay? Because the courts don't want to flip that schedule and make this completely stressful on the child. So take yourself out again of the equation and think about your child. If you haven't been around your child for 2 years or 3 years, or you've been incarcerated, or you just have a substance abuse issue, or whatever else the case may be, the courts want to slowly integrate that in a manner that's healthy for the child so that the relationship is not forced. It creates a much better environment. And, I'm not always saying that the courts are right on how long it takes, but certainly in situations where we're doing that reinstitution, there are available resources and there's ways to do that. If you're on the other side of that, though, Mary, where you've got a parent who's been uninvolved, it's natural to be like, look, I don't want to introduce this parent to this child. I don't want this person around. They're going to do this again. They're going to go away again. They're going to have substance abuse issues again. They're going to, be in situations where they're making statements to a child that are emotionally harmful. And the courts look at this like, look, we're going to give people a chance. And we're going to try to remember that the healthiest thing for a child is to have two parents involved. And we have checks and balances. And if you have a good lawyer and you have some resources, we can make sure those checks and balances are protection measures for the child in the form of remedy. So don't always think of this from a standpoint of, oh my gosh, if this guy gets Saturday from noon to 2, and then the next 3 months go by, all of a sudden he gets a Saturday overnight or she gets a Saturday overnight, that's harming the child. You have to think of it from a perspective of the best interest, which is to have both parents involved. And if you have two parents, loving parents, a loving village, that's the best thing for any kid in the world. And you can talk to any psychologist on the planet and they'll tell you that. And we have to have trust that people can heal. And it's very hard to represent the client where, all of a sudden that new institution or integration of the other parent who's been absent for a while, it's hard for them to trust. And I get it. And those are the hard cases for me, because I tell people, look, you're going to pay me money and you're going to feel like the noose that has been put around them is loosening and loosening and loosening. And over time, that gets frustrating because you feel like your lawyer is, quote, not fighting for you, or the court system is flawed. But at the end of the day, the goal is, again, co-parenting. And so it's a slow process, but there's ways to do it. And I always encourage parents, if you've been absent, get involved. Start with step one foot in front of the other, one day at a time. Don't wait. There's nothing worse than I see than, parents who've just given up on the fact that they can't be around their child because it's been too long, or that other parent is getting in the way of a form of a roadblock. I didn't get to know my dad until later in life. And I am so thankful every day that I had that opportunity. And he was not one of those people that was uninvolved. I just never knew him as dad. And, when you learn those things over time, it creates a sense of confidence that you're loved, you're wanted. I know how to love my kids now because of trips we took when I was in high school that I never got to do at a young age. And I try to project that on my clients and let them know, look, I may not be the most normal or sane dude in the world, but I got a lot out of that relationship. And I think even Andrea can attest, she went through hell in a handbasket and they didn't play nice in the sandbox together all the time. But, those kids have part of their dad in them from birth. And some of those things and some of those qualities and disciplinary tactics and, toughness and all those things that you go through with same-sex couples, man, woman, whatever the case may be, it's necessary to have the more love around them and that communication. So.
And then who are we to judge, right? I mean, who am I to judge the other person? That's somebody else's job. That's not my job. And I think that bad situations also teach kids a lot. I mean, we are raising adults here. We're not raising kids that are going to be kids forever. They're going to learn from those situations too. Like I said, they're smart. They figure out what's right for them. And then in a situation when they get a second chance, they might later on in life be in a situation where they need a second chance. And they see with their mom or their dad that they got a second chance and they were able to make it. That gives them confidence. So again, we forget sometimes, we focus on ourselves as parents and do not focus. They're raising young adults here. There might be only 5 or 6 right now, but they will be adults at some point. And there's always a lesson in those situations for the kids that we might not see right now. And I like I said, I always say that I made a lot of mistakes in raising that because as a mother, you want to protect your kids, but sometimes you just have to let go because daddy is very important too. In other ways, And again, I might not agree with him. And in this case, I didn't agree with him at all. That's the part of the reason we got divorced. But they're 50-50. They're 50 mama, they're 50 daddy, and they figure out their own way. Never forget that.
I love that. So just as we close out here, Justin, we promised that we'd tell people how child custody is handled differently in Texas than in other states. Can you just briefly touch on that before we close today?
Yeah, so I don't pretend to know the laws of all the states in the union, but what I can tell you is that Texas treats child custody in a very statutory way, and people get frustrated by that. And when I say statutory way, when we talk about best interests and we talk about, the situations that create scenarios, for example, the standard or expanded standard being a presumption. Those presumptions in the state of Texas have to be overcome. So we start out with those boxes, and really good attorneys and, really creative thinkers in our space really try to get outside that box and think about possession schedules that really marry up with work schedules and quality time with the child or children. And I think that's important because even though we have these boxes in Texas of expanded standard possession schedule, child support, rights and duties, which I don't like boxes very much, but we have them. And it's not always that way in other states. You see other states with very, very minuscule and limited possession and access schedules that don't really have enforceability to them. And there's pros and cons to that. I get a lot of out-of-state orders that we have to try to enforce, correct, and or modify. And I think it's really important to understand that in Texas, in order to have an enforceable order, which the reason you want enforceability is if somebody doesn't follow it, in order to have an enforceable order, you need to have the who, what, when, where, and why. When the possession schedule is going to happen, where the exchange is going to be, what time it is, and think through those things so that you can gather evidence in the event that you have a party that is not showing up on time or doesn't drop the child off where they need to be. And in other states, you see very loosely based custody orders. Possession and access will be a third of the time as agreed by the mother, or the father. Well, I mean, that's not really enforceable, right? Parties disagree. They come to Texas, they move here, and they say, well, Justin, here's my order that I've spent $20,000 for in California, but it doesn't have these very specifics. And we've been arguing about this a lot. And I said, yeah, your order doesn't really say anything. It just says that you can move and that you have the right to establish the residence, and you guys are going to, good luck, work together for 30% of the time. Well, what is 30%? When is 30%? Is it during the school year? What's contemplated in the event of travel? How do you do that with activities in school and all that? So I would say Texas has done a really good job of making their orders fatter or thicker, if you will, more pages to them. And that's kind of frustrating to some parents when you're having to go through a 35-page order and you're like, wait, this is just Thursday to Monday. What is all this other language? All that other language has been fought through by attorneys. And I know people think attorneys just make fights where fights don't need to be sometimes, and sometimes they do. But at the end of the day, when you have those enforceable provisions and those thick orders, and those boxes that we have are very imperative to create enforceability. It's also equally imperative that a lawyer gets outside and thinks outside of that box to create a possession schedule that's really beneficial for the parties. I get so many calls. I'm like, get that 50-50 or the calculation of a percentage out of your head. There are apps actually right now that you put in the days so that a party can know I have 44.2% of the time. And I'm like, what is that 0.2 have a difference? How does that make a difference? Are you able to be there? Do you work nights? Are you a nurse or a firefighter that has a different possession schedule? Get the percentage out of your head, because if you've got 43% of the time, but 38% of that 43% you're not there, then what is the 43%? And now all of a sudden you have the other party saying, well, stepmom or stepdad is raising the child. They bring you back to court. You pay the lawyers more money, all that. So we really try to think through so that you don't return. And that involves thinking about the box and trying to get outside for the best interest of a child. And that, I think, is the fundamental difference of custody provisions in the state of Texas.
Well, I think that's a great place to wrap up today. Do you guys have any closing comments on child custody here in Texas?
Not at the moment. I think it's really important that we continue these dialogues, not just to think about how to weaponize child custody cases, but really get people thinking about how to do the right thing and be the right people. And as long as we're making some small impact in our little world here on the humans in the universe, and remember that you're impacting and raising future generations, this is more than just rights and duties. This is more than just family law. This is really thinking about humanity, and especially in these times where humanity is all over the place, we have a duty here, and I'm going to do that duty. And whether you like it or not, I'm going to do me. And if you don't like it, well, there's plenty of attorneys who will do whatever you'd like them to do at a cost. But let's just keep an open mind, and let's keep these podcasts flowing. And we want user input in the future to think about topics that they have questions about. We want participation, and we're going to continue to get better throughout this process. And thank you all for listening.
And if you'd like to get in touch with the Sisemore Law Firm, you can call us at 817-336-4444, or you can visit lawyerdfw.com. And of course, please follow the podcast. If you know somebody that could benefit from this information, please share it with them. And again, thanks so much for listening, and have a great day.
Thank you for listening to In Your Best Interest with Texas divorce attorney and entrepreneur Justin Sisemore. The content presented here is provided for information only and should not be construed as legal, tax, or financial advice. Click the follow button to be notified when new episodes become available.